Major breaking news out of the United States Supreme Court. The United States Supreme Court has granted certiorari to the United States versus Rahimi case. This is not necessarily and may actually be bad news. It is not necessarily good news. It might actually be bad news. It's going to be a very complicated trip involving this case. We've got a lot to talk about, but let me give you the highlights when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out if you haven't already bought it. I think you'll like it. Again, it's designed for lessons for Americans to show that we should not make the same mistakes of disarming ourselves, which is the mistake that the Ukrainians made and the price they are now paying for it. All right, folks. I've told you about this case before, okay? The United States Supreme Court today granted certiorari to the case of United States versus Rahimi, which is the case involving a Fifth Circuit Court of Appeals decision that said that 18 U.S.C. 922 G8, involving those subject to restraining orders, civil restraining orders, lose their right to keep and bear arms. Now, the problem with the Rahimi case, which is what Merrick, Garland, the Attorney General, is desperate to take advantage of, is that it turns out, based on the record at least, that Mr. Rahimi is an odious, bad dude. He is engaged in gun-related crimes, he has shot stuff up, and he appears to be, at least from the public record, not to be a Boy Scout, shall we say. So Merrick, Garland, and the Biden administration were licking their lips over this case because the Fifth Circuit Court of Appeals said, look, if you look at the historical analogs at the time of the founding, there is no example of someone who could lose their fundamental right to keep and bear arms based on a civil process. They only lost their right to keep and bear arms based on some sort of criminal conduct, whether they were convicted of a crime or something like that. And because Mr. Rahimi lost his right to bear arms here, allegedly, under a Texas state civil process, triggering the federal statute of 18 U.S.C. 922 G, which provides that one person is not permitted or he's prohibited from having guns if he is subject to a court order that was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate, and restrains such person from harassing, stalking, or threatening an intimate partner or such person or child or such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury or a partner or child. So basically, this is just a standard protective order. But in this case, what happened apparently was Mr. Rahimi did not have an attorney, and he basically consented to the entry of the civil order, and so be it. There was no finding of fact made by a court after a hearing, other than, apparently some sort of general basic information, but, there wasn't any litigation involved and no cross-examination, as I understand, nothing like that. So he lost his gun rights, and subsequently to that, when he was caught with a gun, while he was subject to this restraining order, he was convicted of a crime, sentenced to about 6 years in prison, and that's when he brought his Second Amendment challenge, saying that this federal statute, at least that relevant part of it, is unconstitutional. And the Fifth Circuit said, yes, it is. They specifically said there's no historical analog allowing one to cause the government to take away your gun rights based on any kind of a civil process at the time of the founding. Now, that is what happened. Now, Merrick Garland thinks that this is going to put pressure. Let me tell you how the Department of Justice is thinking about this. And then I'll tell you the issue presented as I see it. The Department of Justice is very excited because they think that there are enough justices on the Supreme Court that don't like criminals. That includes people like Justice Alito, generally good on the Second Amendment. That involves people like Justice Roberts and Justice Kavanaugh, who may be more sensitive to public opinion than maybe other justices. So Merrick Garland is rolling the dice here. And of course, he was going to get cert granted because a federal statute was in part declared unconstitutional, and therefore, that's almost always granted cert. An unconstitutional federal statute that's unconstitutional in part of the country, unenforceable in part of the country, but enforceable in the rest of the country. That's the sort of thing the Supreme Court always steps up in here. So they were going to hear this case or something very similar, and they decided to pick this case. Okay, so that's where we are. So now what Merrick Garland is thinking is that there's a good chance that the three liberals, Brown, Jackson, Sotomayor, and Kagan, are going to team up with a couple quote-unquote conservative justices, if that's what you want to call them, and somehow create 5 votes that's going to dramatically cut back on that quote-unquote Heller/Bruen methodology of look at the text first, shift the burden to the government, and the government has to come forth with a historical analog law that justifies the Gun Control Act. And what the anti-gunners are thinking, and Merrick Garland is thinking, is that in order to hurt, or I don't want to use any particular foul language here, but in order to make sure that Mr. Rahimi is punished and not rewarded in any respect, they're going to look for a way to punish Mr. Rahimi, right? And the best way to do that, according to the liberals, is to somehow broaden the scope of the number of gun control laws that can be upheld using historical analogs. And what the Merrick Garland is thinking is going to happen is this is going to broaden the number of historical analog gun control laws that can be used to justify in future gun control Second Amendment cases the upholding of other related gun control laws. Because right now we've done very well under the Heller and Bruen standard in much of the country. We've won more cases in the last 12 months in favor of the Second Amendment that the Second Amendment had won in the prior 15 years or so. But this is going to be an opportunity for, as Merrick Garland sees, for the Supreme Court to cut the rights bestowed by the Second Amendment dramatically by expanding the number and maybe even the time period in which historical analogs can be used to justify modern-day gun control laws, all in an attempt to try to uphold this aspect of federal gun control law to punish, if you will, Mr. Rahimi specifically. And this gives rise to the old saying of bad facts give rise to bad law. Now, I know a lot of you out there are going to be telling me it doesn't matter, Mark, that he's an alleged scumbag, criminal, a violent thug. It doesn't matter, Mark. Well, yeah, you're absolutely right. It doesn't matter. But I'm here to tell you, and you're here, you come to this channel to hear information and thoughts from a high-end constitutional lawyer at the highest levels of this country about things that realistically go on, not in some theoretical concept, but kind of in the reality in the real world, for better and for worse. And not all of the stuff I like, but I still feel I have a duty to some degree to tell you what I think, even if I don't like it, even if I don't like what I'm saying. I have to sometimes tell you this. And this is an example where I'm not happy that United States versus Rahimi was granted cert, although I think it was kind of inevitable to some degree. And I do think this is a potential risk to the Second Amendment movement, because it's going to pose a problem, because the question is how, and I do think this is the critical question. If the Supreme Court wants to punish, hurt, mess with Mr. Rahimi, rule against him specifically, to rule against him, how do they do that in a way that doesn't screw up the Heller-Bruen standard and make it unworkable or make it very much more pro-gun control friendly than it is right now? And I have a lot of thoughts on this, and I'm going to articulate a lot of views on this. So don't think that we're dead in the water here. But with that said, this is not good news in my view. It may be bad news. We won't know probably for 9 months to a year if it's bad news. But I'm not happy about the fact they granted cert to Rahimi, but I'm not surprised by it either. So again, we're going to talk a lot more about this. I'm going to give you a lot more ideas about how to deal with this case and think about this case. But for the moment, I just wanted to bring you the news that this case was granted cert. Merrick Garland got his wish. The anti-gunners got their wish for the moment. And the fight will play itself out. When the briefing schedule is released, I'm sure in the next few days, I'll report that in to you next week. But anyway, just be aware of this. But I will say, I'm going to end on a very happy note. There was a lot of very good news today out of the U.S. Supreme Court. Very good, I think, ultimately for gun owners and gun businesses and the like. But we're going to talk about that in a future video, because I wanted to focus on Rahimi, because this is a potentially very big deal, and hopefully not a bad big deal in the long run, hopefully somehow a good one, but I have my concerns and I've got my fingers crossed here. But again, we'll talk a lot more about that in the future. So if you haven't subscribed to the Four Boxes Diner or follow me on @4boxesdiner on Twitter, please do so, trying to spread the word of this channel, and I appreciate all your support. And again, if you haven't subscribed to the Four Boxes Diner, please do so, and we'll talk to you again here soon at the Four Boxes Diner.
Orders up. Table 2A.